restrictions. The question is what's reasonable. And really where we're going with our Second Amendment jurisprudence is now to say, well, if the framers of the Constitution at the time they drafted it thought that the restriction was reasonable, which they did. There were sensitive places, there were convicted felons, things like that. Well, then that's the scope of the right. And then once we got that figured out, that's what's not to be infringed.
Yeah, I want to take a moment, too, to talk about what developed after the Heller case came out. So I think we hit the Heller case. They found that it's limited, obviously, it's a limited right, and they went over many circumstances in which we would limit these rights, the Second Amendment rights. They determined that it definitely is rooted in self-defense. They do a deep dive historical analysis saying this isn't just for militiamen.
Right.
This is historically and intended to be for self-defense.
It's not just about hunting.
It's not just about hunting.
I've never liked that argument. The NRA made that argument for a long time. It's not about hunting.
It's not just about recreation. It's about an individual right to self-defense that was recognized and enshrined in the Second Amendment. Okay, so they determined that. They do it in a purely historical analysis, and it was a close vote. It was a 5-4 vote of the Supreme Court, which, just that narrow margin right there changed the course of exactly where we're going, as evidenced by this most latest ruling. But interestingly, and you already hit on McDonald, and McDonald is less significant other than it simply enshrined to the states.
But important, right?
Well, we all saw it coming. There was no surprises there.
But without McDonald, the states can do whatever they want to do because the Second Amendment doesn't apply to the states. So
could have been any plaintiff in any state. It would have happened eventually.
Yeah. Now, of course, it is important to keep in mind that many states, especially here in Arizona, have state constitutions that protect the right to keep and bear arms. So that's a different question. And by the way, lawyers should bring arguments under the state constitution.
We do all the time.
We do it all the time, yeah, but people forget there's a state constitution as well. The states can always afford a higher standard of liberty. They can never give less freedoms in their constitution, but they can be a source of liberty, and said another way, a way to restrain the state government more than the federal constitution says.
Said another way, the federal constitution is the floor of liberty, and the state can give us more liberties. And in fact, several judges and even a Arizona Supreme Court justice that we're friendly with have encouraged us to bring these types of constitutional arguments under state constitutions because they afford more liberties. Yeah,
we're talking about Justice Bullock here, and it's no surprise. He's written articles about this. When I have lunch with him, he always reminds me, hey, Mark, I really want lawyers to bring argument under the state constitutions, and I always tell him, yeah, we do.
Let's talk about something that happened in the interim leading up to this new Supreme Court case. After the Heller case, the federal courts are now left with the Heller case, and they have to do their job. Federal judges have to continue to do their job in light of Heller, and they're required to respect the United States Supreme Court ruling as controlling precedent. But what happens kind of practically is interesting. The federal judges come up with this two-pronged test that at least some of them are trying to interpret Heller in good faith and determine, well, I think that there's a two-pronged test that we should be applying as federal judges whenever we're dealing with a gun regulation. So the two-pronged test basically became for federal judges in the years leading up to this new opinion. It was kind of cool on this point, too, and I should say right now, if you're not familiar with our, what states we practice, and we practice in all of 50 of the states. We do a lot of pro hoc vice work in federal courts and state courts around the country, but specifically we have law offices in Arizona and Hawaii. And holy cow, could those states not be more different prior to this ruling in terms of what their gun regulation is? Arizona, in fact, as you've probably guessed, is a shall-issue state.
Yeah, in fact, it's important to note a couple of things. Number one, you got 43 states issuing rules that can take your guns outside, and they have different requirements, right? In some places, you got to take a class, you got to do this and that. Arizona, yes, you can get a permit, but you don't need one if you're simply a resident here. And you're not a prohibited possessor, which by the way, you could get.
There's a reason they call us the Wild West.
Yeah, and by the way, even if you get a felony in the state court, many of these felonies can be fixed, so you can get your gun rights back. We do it all the time for people. And
now go across the pond over to our other law firm located in beautiful Honolulu, Hawaii, and you will find a very, very different regulatory scheme over there.
I mean, in Arizona, you could go to the gun show where I speak all the time, hand somebody cash. As long as you're a resident, they can hand you the AR-15, and then you can walk right down the street with it. You don't need a permit. You don't need any kind of a license. You don't need to register anything. You can conceal it. You can carry it open. There really isn't a huge benefit to even getting the concealed weapons permit here. I mean, there are some. You can skip the background check. There's reciprocity with other states. You can carry to some places, like, for example, places that serve alcohol that you can't if you don't have the permit. But other than that, you're pretty much free to do whatever you want so long as you're law-abiding. And you know what? You would think, right, for people in New York who are having such an oh my God moment because of this case, you would think, how can you live in Arizona? Well, you know what? It's just fine.
Well, I was going to mention that. The reason why I bring up this stark dichotomy between the states that have these shall issues and these proper cause rules and jurisdictions is because actually before we even need to get to the opinion, in the oral arguments, which I listened to, they were very, very good. You can download all Supreme Court oral arguments, by the way. If you just go to SCOTUS blog or one of Yay has them, maybe we'll put some websites. But if you're a nerd like me, then you like to sit around and listen to these oral arguments. And Arizona got a shout out. I don't know if you remember that. I don't know if you listened to the oral argument, but Justice Alito gave us a shout out, and he basically was talking to the representatives for New York who were defending the law and said, you guys are talking about how these metropolis areas are just going to be war zones after we start issuing these permits. What about Phoenix, Arizona, which is very, very, it's very much a metropolis, very, very densely high populated. They have some of the, they're a total shall issue jurisdiction. Some of the easiest laws in the country
don't even
to get
need
your
it.
firearm.
Yeah, don't even need it. Yeah,
and they do not have exceptionally high firearms violence rates. In fact, they're lower than the national average.
Isn't that funny?
What do you have to say about that? And of course, there wasn't a great answer.
By the way, we should mention and probably put a link at the bottom of this. You did a very detailed overview of this case while it was still pending.
I just want to say, I told Mark as we were walking in to make this video, I said, Mark, there's no reason to even make this video today because I correctly called all of this stuff in a video I did months ago back in January, all 100% predicted. So if you just want to, you can abandon ship on this video now. There's the link to the proper analysis.
So in Hawaii, I was just over there and did a show over there, and they're so excited over there because they got the right to keep and bear stun guns. So competent adults now can walk the streets of Honolulu with a permit and proper training and everything else with these stun guns. And I see these guys walk in and they're carrying them on their hip. And I said to them, very shortly the landscape is going to have an earthquake over here because when this case out of New York gets decided, the people of Hawaii are going to be treated like big boys and girls and are going to actually be able to carry guns down the street. Now, I want to be clear about this. Hawaii's going to still, like all these other 7 states, are going to still have the right to require that you get a permit. Mm-hmm. They can still require that, and they probably will, that you're going to have to get some training. You're going to have to go through a background check. You may have to go through some kind of a mental health. I don't know. These are the things that we don't know. There was some reference in this case that, if they take a long time to issue the thing, that could be a problem too. Come on back to court, because if you're sitting around waiting month after month after month for the permit to be issued, that might be an unreasonable restriction on your Second Amendment right to keep and bear arms outside the house. But the law is going to change. The case was remanded back to I think it was the Second Circuit. They're going to make a decision, issue it, and then there'll be some period of time that the authorities in each state are going to have to come up with what boxes do you need to check to get the permit. Now, of course, we'll be standing by, right?
We're champing at the bit to help people, to help law-abiding, competent citizens exercise the rights recognized and enshrined in this case.
Yeah, because that the people on the other side who don't like this case, many of them take the position that the dissent took in this case. Justice Breyer's dissent and Justice Alito's criticism of that dissent. In fact, I have it. I think I pulled it out. Yeah, I just want to read what Alito said about Breyer's dissent here. He says, like that dissent in Heller, the real thrust of today's dissent is that guns are bad and that states and local jurisdictions should be free to restrict them essentially as they see fit. That's what's on the other side of this. So we can imagine the people in those 7 states who are very frustrated.
Maybe
with
not
this.
the most charitable framing of Justice Breyer's argument, but I think the conclusion's pretty much correct.
Yeah, I think so too. So we should expect that there are going to be some onerous requirements to get the permit to keep and bear arms outside the home, and that's what we're standing by. We want to litigate these cases.
Absolutely.
Yeah,
we
absolutely.
love these cases.
Yeah, we love them.
So I guess just to kind of reiterate what the findings were, because I feel like we breezed over just a little bit. The end result is basically that laws that put these types of onerous restrictions on people from being able to carry out in public is just too much. It's unconstitutional. And very, very importantly, remembering how we were discussing the kind of two-pronged test that was created in the years between Heller and Bruen, the interesting thing is the court said it ain't a two-pronged test anymore. In fact, as they said, it's one prong too many. We're getting rid of this second prong where the judges are doing these balancing tests of, all right, what's the legitimate state interest and is it substantially related, and kind of analyzing things like gun violence and analyzing things like effectiveness of guns in killing other human beings, and what areas are hot zones and what areas are statistically more likely to have more deaths in certain ways. And they said, we're not even going to touch that because that's not our role as justices. Now, this, I think, is an admirable position to take, which is that if there's one thing, and I think of it also in the wake of the Roe v. Wade ruling, if there's one thing I don't want these old late 80s, early 90s crotchety judges who have no actual touch with the voters of the country, aren't armed with the knowledge of these highly complex issues. If there's one group of people I don't want making those types of decisions and weighing statistics outside of their wheelhouse, these are lawyers. These are career lawyers. I don't want those people to be the people to weigh the empirical arguments on these things. They should kick those decisions to where they belong, the legislature, right? And so by saying all we engage in is a historical analysis to see, was this correctly decided, was it not correctly decided, we don't touch the empirical weighing of everything like that. I think that's aspirational. I wish more justices would take that position.
Yeah, I'm not so sure whether that's going to be the right decision or not. I think time will tell. They do engage in this balancing test in the area of First Amendment jurisprudence and in many other areas. And as long as they're applying strict scrutiny, it's fine. Freedom is generally protected pretty well. I wish we could get rid of minimum scrutiny, make everything strict scrutiny. I like and I often talk about the Lochner era case. This is a case well before West Coast Hotel. I think it was like 1905, the Lochner decision. When that's what the court did. Every law that was passed by a state legislature or the federal Congress came into the court with an idea that it's there's a presumption of liberty. So if you're going to infringe on somebody's liberty anywhere, you better prove you better carry the burden. And so I kind of like that. That's more akin to either an intermediate or a strict level of scrutiny. So now we're taking that away. This could be it could be a double-edged sword here, because if something's not historically protected, right? And we have lots of things now that didn't exist at the time. So it could work in the other direction as well.
Well, if something's not historically protected, you go and pass a law. You go and amend the Constitution if necessary, but you go and pass a law if it's not historically protected.
But you might say, for example, subways didn't exist at the time that the Second Amendment was written. Therefore, subways aren't, they're sort of off the table. You can regulate anything you want on a subway, no guns.
You go and pass a law that talks about scope of regulation.
Yeah, but
this is an easy solution.
But the question is whether the Second Amendment applies to that spot. Is that a sensitive area? Well, they didn't exist at the time, so I don't know how that's going to shake out. What I want is liberty protected. What I want is that safe, competent, responsible adults, as long as they're not presenting a substantial risk to another person, can do anything they want with their property. That includes firearms, right? Now, there are many ways you might be presenting a danger to another person, and we need to talk about those. And if you are, you should be deprived of the weapon. But if you're not putting another person in danger, that's what freedom's about. One thing that I did want to mention before we end the video, I was very disappointed by what some people in power have said in reaction to this decision. I just noted President Biden's comment. Very disappointed by the decision. Contradicts common sense and the Constitution. Really? Contradicts the Constitution? I wish we had him here on the show. I would say, what part of the decision do you think contradicts the Constitution? What a ridiculous statement to make.
As the Heller Court very, very, very excruciatingly clearly explained, it is very much rooted in the history of the Constitution, and the Constitution clearly meant that you're supposed to be able to carry a firearm for the purposes of self-defense. So I'm just as curious. I don't think that was a serious legal jurisprudential analytical statement. This was playing for his team, who was probably upset.
You're the president of the United States. Come on. And then the governor of New York, reckless decision, reprehensible, frightful. Really? What's so reprehensible about saying that the Second Amendment that makes it very clear that the right of the people to keep and bear arms shall not be infringed, when they say, if you're a competent adult and you can check all the boxes, you get to carry your firearm outside your home for self-defense. Like, what is so reprehensible about that?
Also very troubling to me is the Department of Justice came out and made a statement.
They sure
said,
did.
Oh, yeah, it's horrifying. We totally disagree with them, everything like that. It's like, wow, we're not... Everybody in all branches of government are just political hacks at this point.
Why couldn't
playing for their teams? We can't keep a little modicum of respect for the decisions of the other branches?
I would have preferred a statement, even if they're going to say you're disappointed at the end, but
we will enforce it because that's our job.
And the way our system of government and constitutional republic works is the Supreme Court gets to say, since Marbury versus Madison, they get to say what it means. They've spoken very clearly what it means, and it's our job to enforce that construction of the Second Amendment. I would have appreciated a statement like that. So we got
just yet another sign of the times of how polarized everything is right now, and everybody's divided into two teams right now playing for their teams.
Right.
So
no.
We need something different, Mark.
Yeah. Live and let live.
Yeah, that's right. Go check out the Peace Radicals podcast if you want to learn more about that. And if you want to learn more about our law firm, attorneysforfreedom.com. We are licensed in Arizona and in Hawaii. Very, very different gun laws in those, though they're about to get a little bit closer in the wake of this new decision. And, of course, we accept gun cases and all kinds of cases all around the United States. If there's an important issue going on near you, an important fight, a freedom fight that needs to be had in the wake of this decision, we're your lawyers. So don't hesitate to reach out. Mark, any closing thoughts?
Well, I think this is really the beginning. Now we're going to see exactly what restrictions can be put on the right to keep and bear arms outside the home, and the litigation just begins at this point. So I would encourage people, look, we're not going to take the case if we don't believe in it, right? But if you've got a legitimate argument here and you think that the state is impairing your Second Amendment right to bear arms outside your home, and you are a competent adult, and there's a long delay, there's some unreasonable...
Yeah, there's a lot of weird things around the edges, right? It's not enough for them just to say, oh yeah, we'll issue it. Yeah, it's coming. We've determined that our tests that you have to do are reasonable. There are a bunch of important questions here.
So when the state of New York says, there's a $10,000 application fee to get your permit to carry outside, things like that, those are the things we need to fight. Like the Founding Fathers said, you get liberty, you get freedom only if you're willing to fight for it. It's an endless struggle because the people who want to take away your freedoms and run your lives, they're always chomping at the bit to take away liberty, and we're interested in protecting liberty, and there's always another fight. So this is the beginning. I think that our position here is that reasonable and competent adults who do not pose a substantial risk of harm to other people should get to do what they want in all areas. And if you feel like you're being deprived of that liberty in the United States, give us a call and we'll screen your case. And if we think it's a good case and you want us and we want you and we got a match, let's do it.
Give
let's
us
fight
some
the
freedom
fight.
fights. We love them.
Yeah.
Well said, Mark. Thank you very much, guys, for tuning in today. Hope it was informative and interesting for you. And stay safe out there. Take care of yourselves and your family. Attorneysforfreedom.com. liveandletlive.org. Peace Radicals podcast. Shameless plug, shameless plug, shameless plug. Thanks for tuning in. This is attorney Andrew Marcantel and attorney Mark J. Victor. Take care.
Peace.